Okay. Good morning and welcome to the 11:30 session of the court. The next matter on our docket is Kelly Land Holdings versus Lee Arnold and Associates. Mr. Kula, I believe you represent the appellant in this case, and if I am correct, did you wish to reserve any time for rebuttal?
Yes, Your Honor. May it please the court, I'd like to reserve 5 minutes of my time for rebuttal.
Okay, I will try to intervene as you were presenting to give you fair notice.
Thank you so much.
You may proceed.
Thank you. May it please the court, again, I'm Elliot Kula. I'm here on behalf of appellant Kelly Land Holdings. The trial court granted summary judgment based on a pleading defect, which Kelly Land Holdings sought to correct by amending its complaint. And to be clear, the amendment, which fully resolved the defect, sought merely to change the designations of the parties from third-party plaintiff and defendants to party plaintiff and defendant.
Counsel, that's one way of putting it. Another way of putting it is that it completely changed the very essence of the pleading itself. By changing those designations, you are transmorphing, changing what was a one kind of recognized pleading, a third-party complaint, into a completely new lawsuit, really, to a new complaint. That's not usually, I've never seen a case that has permitted an amendment to change outright. Usually you get an amendment and it goes from third-party complaint to amended third-party complaint or second amended third-party complaint. That's not what you all were seeking. You all were seeking to file the very first complaint in your own rights in this case. So is it really an amendment?
Yes, it was, and here's why. The underlying facts and circumstances and transaction occurrence remained the same. The claims remained the same. These parties have been litigating these claims for several years. Nothing changed. This case was still ready for trial. There's no suggestion or allegation that perhaps the trial could not go forward. There's no suggestion that additional discovery would have been made. There was no additional drag on this case. This really was just amending the designation of the parties and nothing more. Now, it did eliminate the need.
But Mr. Kula, you were attempting to amend the third-party complaint to eliminate the summary judgment issue because you weren't bringing a proper third-party complaint. And I suppose that because the way the case was brought the way it was, you couldn't bring a separate action because of the statute of limitation issue, which is a different issue. And I would suspect that the clerk might have an issue because in essence, you're bringing a new independent cause of action because it's no longer a third-party complaint without paying a filing fee, right?
Well, there would not have been a filing fee for...
Because you're asking to bring a new cause of action within an existing case in which you brought an original third-party complaint.
But remember that the cause of action hasn't changed. The nature of the claims.
Right, but there's nothing, and I guess, and we haven't even talked about the rules yet. What in the rules allows you to do what you want to do?
Well, we were traveling under 1.190, which allows amendment to pleadings at any time. There's a three-pronged test established that this court has long recognized. And that's the three-pronged test we were traveling under. And keep in mind as well, the trial court's ruling was simply that our motion post-dated their motion, therefore their motion would be granted. That is not the test.
Okay, but I mean, put that aside. I not necessarily agree. I don't agree with that or the reasoning as to how the court came to the decision that it came to. But just taking your motion to amend, let's say, you know, you had it heard. I don't see how you get to where you wanted to go without filing a separate independent cause of action, because it cannot sustain itself as a third-party complaint. And I don't see that the rules allow you to do what you wanted to do.
Well, I'll refer the court to the caduceus decision, which we've discussed in our brief. In that case, there was a conversion of a third-party defendant into a party defendant. The Florida Supreme Court had no problem with that.
Right, because in that instance, it's still a complaint that's going forward as an amendment, and there's a specific provision in the rule that says that a plaintiff is allowed to bring claims against third-party defendants as if they were defendants. So you had two different bases there that to me very much distinguish your case from what happened in Caduceus.
But what is drawn from Caduceus is that 1.190 does apply in this context. The court applied 1.910. There was overlay with 1.180. The other side is arguing that these are mutually exclusive rules. Caduceus answers that question and says, no, they're not mutually exclusive. Under 1.180, we have a test to apply, and we apply that test here: prejudice, abuse of process, and futility. We've passed all three of those prongs of the test. There's been no argument otherwise. Nothing in the underlying cause of action has changed in terms of the facts, the circumstances, the transaction. All those facts are fully developed and the case is ready for trial.
Let me ask this. In order to properly invoke the jurisdiction of the circuit court, would you not have had to file an original complaint and then caused it to be served? And if that's true, then what you are attempting to do by amendment to the pleadings is to now acquire jurisdiction on behalf of your clients, which you did not originally obtain by not filing the proper lawsuit. You have to file your lawsuit. If you had a separate cause of action, you're not a third-party complaint. To invoke the jurisdiction of the circuit court, you would have had to file a civil lawsuit and then cause process to be served, right?
Yes, but keep in mind how this action arises. Where this action arises is part of the underlying litigation. Going over the course of
because it's not a proper third-party complaint. That's your problem.
I understand that.
It doesn't arise out of that. Otherwise, the court would have allowed it to go forward, but it didn't. It didn't allege subrogation, indemnification, or contribution.
To be sure, it did not have those allegations in it. And had there been a motion to dismiss this third-party action while the principal action was still pending, that would have been a viable motion to dismiss. But we're not in that posture. We've resolved the primary action, and we're moving the third-party action into first place. That is just an amendment that's not altering any other factor in the case. We came into this case. This case that is before the court today arises out of the third-party action tangential to the principal cause of action. Again, had there been a motion to dismiss, that would have been one situation to deal with, but there wasn't. And now we're in a
the court was permitted to deal with this issue on summary judgment. Certainly the case law fleshes that out, that summary judgment is appropriate. I guess the only issue that I have is whether or not it should, it's a final summary judgment. I mean, certainly, I guess the court could have allowed you to file an independent cause of action, which the case law permits. So the problem is that the statute of limitation has run. And so in essence, it's with prejudice because you couldn't bring it now because the time period had elapsed.
That would be the prejudice to us.
Well, I understand that's the prejudice argument.
But of course, under the three-pronged test for amending a pleading under 1.190 in the cases out of this court, we're talking about
that assumes that you're amending a pleading, and I'm sorry, I'm having a hard time. There's not going to be an amended third-party complaint coming out of this. You're not amending that pleading. You're filing a new one. You're changing your pleading. It may be a cut and paste job of the earlier pleading, but it's a new action. And that's where I'm having a hard time getting past that. Maybe you can help me though with this issue, because what's bugging me about this, it doesn't look like that was the basis that the trial judge relied upon when she granted summary judgment. So how should that affect what happens here on appeal? Because I don't believe that she ever said or that she ruled that yeah, it looks like this was never a proper third-party complaint. As such, sorry for that basis. I mean, it seems like she kind of almost went with you on the amendment issue, but applied it in as to prejudice, but then applied it in a summary judgment context. And help me out. What do you think that ruling was about? Because I'm having a little hard time understanding it.
I think the best place to see the analysis that went into the ruling is on page 1620 of the record. That's the hearing transcript on the motion for summary judgment, where the court stated their motion for summary judgment predates your motion to amend. And so therefore, she wasn't even going to consider a motion to amend, whether proper or improper, wasn't going to reach the issue that Your Honor is talking about this morning. The trial judge ruled simply that because the motion for summary judgment was filed first, I'm not going to deal with any amendments. That ruling was an error. That ruling was an error on a de novo review that would require reversal.
Well, only if you were caused harm by that error, and that's maybe how this ties together. Because I'm not sure that even if the judge had gotten to the motion for leave to amend, even if she had considered it, then we're right back to what we've been talking about this morning, right? So okay, so let's say we reverse and send it back. Okay, consider the motion for amendment. Where are we then?
I agree. We are where we are right now, which is the opportunity for amending a third-party complaint. There's no authority.
If it's an amendment that you're seeking, which we're still
that,
not sure that that's really what it is.
There's nothing that precludes that amendment. A third-party complaint is a pleading. Rule 1.190 provides for amendment to a pleading, changing the designations. Which
there's nothing in the rules that prohibit you filing a 10th party amended complaint, but that doesn't mean that it's something that would be recognized, right? I mean, I'm not sure that argument gets, well, just because this isn't explicitly recognized in the rules, that therefore it's not prohibited. I'm not sure that gets you there.
We're talking about whether or not the cause of action changes, that this is a whole new lawsuit. And our position is that nothing changed. Litigating this.
It's a completely different lawsuit because it's no longer than in the posture of a third party complaint. And so you're asking to take a completely separate and distinct third party complaint, which was improper to begin with, and then amend it to an original action.
And again, the reason this is coming about this way is because the principal action resolved. So that first.
Yeah, but this is not how, when the principal action resolves, the third party complaint does. I have not seen a case where they've taken it and substituted it into the original action, because the third party complaint comes with it and it's limited to the damages that the original cause of action had. And so the nature of the proceedings remain the same. I've not seen a party do what you want to do. And I recognize that the only way to alleviate the prejudice with the statute of limitation is to do what you want to do. I just don't see where this is permitted by the cases or certainly by the rules.
At the risk of repeating myself, and I don't want to belabor the point, our position as argued in the briefs is that Rule 1.190 allows for amendment of a pleading. A third party complaint is a pleading. We've sought to amend that. There's the Caduceus decision out of the Florida Supreme Court recognizes that the third party actions shift and morph. That's what happened here. There's been no suggestion that there's any prejudice to them. There's no change in the underlying cause of action. There's no need for any additional discovery. There won't be any further drag on the litigation, and it avoids the prejudice against us with respect to the statute of limitations. Respectfully, we request the court reverse the order denying the motion for leave to amend because it's based on faulty reasoning, and remand with instructions to allow the amendment, and with that, I'll deny the motion for summary judgment so our action can proceed against the defendant in this case. I'll reserve the rest of my time for rebuttal.
Your counsel. Attorney Rooney.
Good morning. Carol Rooney for the Appellees. May it please the court. Your Honors, this appeal involves a relatively straightforward issue, whether or not the third-party practice rule permits the requested amendment by the appellant. And as this court aptly recognized, what the appellant is seeking is not an amendment. It's actually a metamorphosis, turning an original third-party complaint into an underlying complaint. And there's simply no authority for that.
Is that really the issue here, though, given the trial court's ruling and summary judgment? I mean, the trial court's ruling was, nope, I'm not going to even look at the motion to amend because the motion for summary judgment preceded it. And that is just erroneous, right?
Your Honor, I don't believe the timing of it was really the basis of the trial court's ruling. And I would refer the court to record page 1620. And the court actually advises the appellant's counsel, it says, but you all filed under the wrong authority. You all have had 10 years to figure it out. And that's why I asked about Centurion. When Centurion was out of the case, then you all had the opportunity to file this as a cause of action, as a separate cause of action and not under indemnification, the other two causes that he enumerated. So I believe the trial court was aware of the issues. I don't believe that the ruling was simply based on our motion for summary judgment predated their motion for leave to amend. But again, even if that was the case, it would be harmless. And under tipsy coachman, what the appellant is requesting the trial court to do is not permitted. So there's no basis to reverse just simply on that, because they never contested our summary judgment. They agreed that they did not have a valid third-party pleading. That's not challenged on appeal. They're basically trying to carve out some kind of, that this is an amendment to a pleading, but it's not, they're not amending their pleading. They're attempting to change it into something else. And there's no authority for that. There's no authority for that under the third-party practice rule and all of the case law. The Legier case, that was never, I mean, why wouldn't the appellate court in that case just change the nature of the pleading? Rupp versus Philpott. We have case after case after case. And then there's two cases that actually talk about, Gatesland and Firestone. In those cases, leave to amend was sought to amend the third party pleading. In one case, it was denied because it would be futile. They would not actually amend it to state a proper third party pleading. And the other one, they allowed it because they were able to do it. So that's the analysis that should be employed. They have never sought an amendment to add indemnification, contribution, or subrogation, which would make it a valid amended pleading. That's not what they're seeking. So there's no way that they've shown any error whatsoever or abuse of discretion on the part of the trial court. The trial court did not make an error of law. She did not abuse her discretion in denying leave to amend, because really amendment was not even sought. They were trying to change the complaint into something completely different. The Catesis case, I think the court has recognized, it has no bearing whatsoever on the issues before the court. It doesn't really involve the third-party practice rule and whether it states a cause of action or not. It was merely whether or not the original plaintiff could sue a third-party defendant and have the statute of limitations relate back. Those issues are not presented today. This is not a technical amendment by any means. It's basically, again, changing the third-party pleading into an underlying complaint, and there's simply no basis for that under the Florida Rules of Civil Procedure. The proposed amendment would certainly be futile because there's no legal support for it. I believe the prejudice is really kind of misplaced here, the prejudice analysis. It's either the pleading complied with Rule 1.180, the third-party practice rule, or it didn't. It's not really even a consideration for the court, so I see that as simply a red herring issue. And certainly we as the appellees should expect that the rules of civil procedure should be applied and followed as written, and there was no basis to deviate from them here. The timing of the issue, the fact that it was pending for 9 years is another red herring issue. I think the record speaks for itself that any delays were basically caused by multiple changes of counsel, failure to prosecute, and other issues. And that doesn't really change anything. So really, frankly, this is a straightforward issue. There's absolutely no support for what's requested by the appellant to change the third-party pleading to an original underlying complaint. That's not authorized under Florida law. The trial court made the correct decision. And unless the court has any other questions for me, we respectfully request that the final judgment be affirmed.
Thank you, counsel. Okay. Okay, counsel, you still have your 5 minutes ready for rebuttal. You may proceed.
Thank you. The suggestion that there is no authority for this amendment, there's no authority that says this amendment should not be allowed. Rule 1.190 allows for the amendment of pleadings. This is an amendment by interlineation. It could not be any more ministerial. We are striking out the words third party. Everything about the facts, the circumstances, the conduct, the transaction underlying the claims remains the same. The discovery, the trial preparation that has been undertaken by the parties, all remains the same. The schedule for trial would have remained the same. This really is a technical amendment. This is a technical amendment in that it, by interlineation, strikes out third party. Again, the case had been prosecuted and developed as a principal action and a third party action. The principal action had resolved, and this case moved into first place, and the parties were redesignated accordingly, and that resolved the pleading deficiency. When we look at the three-pronged test that Rule 1.190 directs and that this court has found applicable, we see that there is no meeting of the dangers that exist under amendment. The prejudice is, still this morning, no prejudice has been identified. There's no delay, there's no drag in the proceedings, there's no need for additional discovery, there's no failure of notice as to the causes of action that are being pled. There's no abuse. That's been agreed to. And there is no futility, because if we do strike out third party, then the pleading deficiency on which the summary judgment was asserted, and that it is gone. So the motion for summary judgment no longer has any legs. I want to go back to the trial court's ruling, which was about the timing. It was not about anything else. We see that at the transcript where the judge says, your motion post dates their motion for summary judgment. The timing, we know from the case law dealing with amendment to pleadings, the timing is insignificant. At most, it's incidental. Pleadings can be amended up to the time of summary judgment, even after summary judgment was granted. This is a technical amendment, a technical defect in the pleading that was amended by interlineation. The trial court erred in adopting the wrong law in denying the motion for leave to amend. With respect for the request, the court reversed the order denying the motion for leave to amend, remand with directions to grant that motion, and along with that, deny the motion for summary judgment, the defect in the pleadings having been fully resolved. Thank you.
Thank you, counsel. Thank you both. Now we'll conclude this argument, and we would ask you to go ahead and exit the meeting, and we would call the final case for today, which is Kelly versus Kelly. I'm sorry, Webb versus Webb.